Hi everyone, it's Wayne Jones, the course coordinator for Australian Employment Law at Central Queensland University. This is week 2. Last week, just to remind you, we looked at an introduction to employment law. We talked about the constitutional basis for employment law, which led us into the next question, which was coverage. Which laws, which jurisdictions covered which particular workers? Something that you'll always need to do first, as a first step, when you're sorting out an employment law problem. This week we'll look at who is an employee in the first lecture, and then I'll talk about special types of employment. So I'd ask you to read chapters 3 and 4 to Stuart's Guide to Employment Law for week 2. And if you want to do any additional reading, look at chapters 7 and 8 of Creighton and Stewart's textbook. In chapter 7, you can stick, if you like, just to the material which relates to types of employment and employment laws, particularly the difference between contractors and employees. Okay, well, employment laws are generally concerned with paid work, not necessarily voluntary work, and certainly not work as a contractor. So when we talk about employment law, we're really talking about paid employment. Now, the roots of this week's material, I guess, go back to torts. So if any of you have completed your torts course, you'll know what I'm talking about when I mention vicarious liability. Vicarious liability is the liability that the courts have found where an employer is liable for the things that their employees do. Now, particularly because it's torts, they're responsible for injury and damage that are caused by their employees. And your textbook refers to a case for you to have a look at called Sweeney against Boylan nominees. I'd ask you to have a look at that case and you'll get a feel for it, particularly if you haven't done torts, you get a feel for this issue of vicarious liability. But essentially what it means is the courts identify whether someone is an employee or not, and if they are an employee, they will find, in the right circumstances, that their boss, the employer, is liable for anything that they do, particularly where they injure someone or cause some damage. Your textbook also refers to a concept of a non-delegable duty of care, and gives you a couple of examples, but I guess for our purposes this week, as much as we need to comment on is the fact that the vicarious liability that a boss, that an employer has over his or her employee is not delegable. So it doesn't really matter if the person is off working for someone else momentarily, for example. It's a non-delegable duty of care. The obligation to compensate the injured person will go back to the employer. Coming back to my initial comment about employment laws generally being concerned with paid employment as an employee and not as a contractor, your textbook also makes the point that only employment applies to the regulation of employment conditions in the Commission, in awards and modern awards, and in the National Employment Standards. So those three, for example, are only interested in employment. The commissions, the National Employment Standards, etc., aren't interested in and don't apply to contractors. The legislation which deals with employment conditions include long service, workers' compensation schemes, unfair dismissal, intellectual property, and tax to be deducted. All of those acts, all of those laws, again, just apply to employees. They don't apply to contractors. Another exception which gets a mention is the issue around deeming. So some laws, both the state and Commonwealth, some laws may deem an arrangement which would otherwise be employment, can deem something to be employment, even if it might otherwise look a little bit like contracting. So for example, the textbook provides the example of the New South Wales legislation, which relates to outworkers and the requirement to pay payroll tax. What you'll find is that generally these deeming provisions will apply in situations around revenue. The payroll tax, I guess, is a good example for that. There's not much mentioned in your textbook, but if you do get a chance, have a look and see just how broad the net is, so far as the definition of employer is concerned. Just see how broad the net is for the obligation to pay superannuation guarantee. From personal experience, I can tell you that where a company employs, ostensibly employs somebody as a contractor to do a job of work, it may be very easy for them to fall across the line so that the employer needs to make a contribution to superannuation for them. So pretty much on point there. Some laws can deem an arrangement, which might otherwise be something else, to be employment, particularly in response to public policy. And then, of course, there are some laws which apply to both employees and to contractors. And the two best examples which are given are laws regarding discrimination. They apply both to employees and to contractors. And also I should mention, so far as discrimination is concerned, that goes hand in hand with victimisation. So to victimise a person who's made a complaint under anti-discrimination laws is also something that applies equally to employees and to contractors. And of course the big one that'll come up time and time again is that the workplace health and safety regime, not so much the work cover, but the workplace health and safety regime spreads a very broad net. And so probably some of you are aware that even visitors to a site are owed certain duties by the person who's in control of the site. So it's a very broad net. And so workplace health and safety obligations apply to both employees and to contractors. Let's think about the definition of employee over the definitions which have been applied for a contractor. There are a couple of great cases. The two which I'm going to ask you to have a closer look at if you get a chance are the two which are mentioned in the text. That's Stevens against Broad Rib Sawmilling and Hollis and Varbu. Now the second case, the Hollis case, was a very big deal a couple of years ago when it first came out. It really did put the cat amongst the pigeons. And it was the case that involved the bicycle courier who to this day has never been identified, but he ran a man down who just happened to also be a courier but not a bike courier, knocked him over, apologised, jumped on the bike and took off. But the man who was injured saw that he was wearing the uniform of a courier company. That was as much information as he had, and so he and his lawyers went about suing that company. So have a look at it, because it's good authority for the proposition that somebody who may look like a contractor, certainly may for our purposes, in fact be an employee. The opposite was found in Stevens and Broad Rib Sawmilling. Again, an injury case where a man who was helping to load logs onto the back of his own truck was injured by the operator of a bulldozer. Now, in that case, as is the case in a lot of these examples, everything's fine until someone suffers an injury or wishes to make a claim of some sort, and that was the situation there. So Stevens was desperately trying to say that although he and the person who injured him were subcontractors for some purposes, that either for the purpose of the work cover claim he was an employee, or if that didn't work, then he was entitled to say that Broad Rib had a duty of care which was non-delegable, so that both of the workers if anything happened to them, could refer back to the, if you like, what they thought of as the head employer. We'll have a look at the case because it's a really good run through of the tests which are applied. So I guess to that extent the outcome doesn't matter much, but I can tell you that the claim was not successful. Stephen's claim to be an employer was not accepted by the court. But look at those two cases. If you look at no others, have a look at those two and make some notes about them because I think you'll find them quite useful. Now your textbook confirms that the courts apply a multi-factor test. And here are some of the terms that you see bandied around. So when they talk about a multi-factor test, in a moment we'll see the case that's referred to is Abdullah and View Days. But if I just go back, those 14 items that get a mention in that case fall into these, if you like, these sort of categories. The courts tend to look at control. How much control has the employer got over the person who's alleging that they are an employee? What's the overall impression? That's another term the courts tend to use. They don't just look at bits and pieces because there's so many different elements to being an employee. They'll look at the overall impression. What's the totality of the relationship? So once you look at all the bits and pieces, all of the different tests, what's the totality? And I guess that relates back to this overall impression. And most importantly, the courts don't seem to feel that they're bound by the terms of any contract or agreement. So the parties, particularly in this end of the world, the parties will tend to sign all sorts of agreements, contracts, etc. And the courts say, well, look, you don't get the final say. We'll have a look at what the contract says, but we're much more interested in the actual work practices. So you might say one thing and do something completely different. Now, I won't go through all the different cases that get a mention in the textbook, but please have a look at them because I think that they're good examples of the tests the court applies. The major indicia, these also appear and are referred to in places like the Australian Tax Office. They've got some guidelines on their site about who's an employee and what sort of tests you apply, and these are the ones that come up a lot. Again, have a look at them for yourself, but things like how much control over the work that is to be performed does the employer have? How integrated into the business are they? Do they wear uniforms? That was the case, of course, in Hollis and Babu. The guy was only identified by his uniform. Do you need to bring your own tools and equipment and maintain them? And have a look at some of the cases on that because you'll see a reference in the text to the fact that it's not just having the tools, but are we talking about quite expensive equipment? There was a case which rated a mention in the text. Trying to find it quickly without much success, but look, in the case where the equipment is quite expensive, here we go. It was the Australian Air Express case on at paragraph 3.11 in your textbook. They point out the fact that in that case, although it was a similar arrangement to the courier arrangement in Hollis and Babu, the person had quite an expensive truck and was able to substitute other drivers, etc. So have a look at those indicia and just bear in mind that you still need to look at the overall impression that the court is left with. Okay, look, one of the strong tests is whether the person has the power to delegate what they've been asked to do. And your textbook makes the point that having the power to delegate to anyone is pretty well incompatible with a contract for personal services. So think of it this way. The employer has asked a particular person to do something. That person has agreed that they will take up the role, take up the task and do the work. The contract is very much between the two of them. Some of the early cases started to differentiate that by saying, well, particularly where the person provided plant and equipment, that no, look, what we were really interested in hiring was your bulldozer or your truck or the equipment that you came with. We didn't really care whether you did the work or not, and in that case, you really are a contractor. But where the contract is clearly with a particular person, then being able to, that person then being able to unilaterally say, look, I don't think I'll do it and I'll get somebody else to do it, is incompatible with an employment arrangement. However, note the comment that an absolute prohibition against delegation might also equal employment. And that again is back to that indicia around control. If there's such a high level of control that the person isn't even able to delegate, then it probably does amount to employment. Now, there were a list of cases starting at 3.11 in your textbook. They do run over the page as well, including that Australian Air Express case, and the one that we mentioned earlier in the notes, that was Sweeney and Boylan nominees, about vicarious liability. Just at least have a quick look at those cases and get a feel for what the facts were. So you don't need to make an entire case note unless you want to, except I'd recommend to you the Hollis and Babu case, for example. I think that's probably worth doing a case note about. And the sawmilling case, which I mentioned as well. I think you need to do a case note on Stevens and Broadrib sawmilling. I think that would be useful. But at least have a look at the examples that are given. Why do people do it? Why do they want to? Why do they want to be seen as a contractor rather than an employee? Well, let's go first of all with the employee. Lots of times the person will make an approach and say, look, I would rather keep a little bit of flexibility to our arrangements. Again, an example here at the university, we'll have an approach by someone who really doesn't want to get too tied into the whole university system, including policies and all the rest of it. They just want to come and do a short job of work, and so they'll be more in mind of trying to convince us to give them a contract. Now, not just a short-term contract, but to treat them as a contractor. So employees like that feeling of control. They like to feel that they're self-employed, that they're their own boss. And of course, sometimes they believe that they're going to be able to reduce their taxation, and more about that a bit later on. From the employer's point of view, it's more often about avoiding all of those onerous conditions of employment, the things such as having to organise work cover for the person, having to be prepared to pay them some sick days if they're unwell, making contributions to superannuation, making allowance for leave, etc. All those sorts of things. So, and remember also that if you can convince somebody else to come on with onto your job with all of their own equipment or their own plant, organise their own insurance and what have you, you're reducing risk as well. So I know that the textbook tends to refer more to the costs, but there's also an element of reducing risk and reducing capital expenses if you can get somebody else to bring all that stuff with them. So that's why. How do people try to do it? Well, you'll see from the text a reference to trying to draft a contract that at least looks like it might work. Some of the things that come to mind from my experience that we do try to make sure appear in the contract are, we do make it plain that, all right, if you're going to do that, then we can't really have much to say about you substituting somebody else who's got the same sort of skills as you if you want them to step in and do the task for you. We make it plain that the contract is about producing a particular result for us. In other words, again, our example might be that you'll produce a set of study notes for a topic, or you'll produce some material for us. We make it plain that you're required to have your own insurance, and as a requirement of the contract, it might say we'd like to have a look at that insurance before you come onto the site. So essentially what we're looking at is making sure that when we draft a contract, it addresses those 14 indicia that I mentioned earlier. Okay. One of the best ways to ensure that you do break that connection and that it's fairly clear that what we have here is a contracting arrangement and not some sort of disguised employment is interposing another entity. Now, the best example of that at the moment, and one that again hasn't mentioned in the text, is through entering into a contract with an agency which hires staff out. So you'll see in the next chapter a reference to a triangular arrangement where the contract is entered into by the labour hire company with the employee. They look after all that arrangement. And so if I need a worker, I don't talk to the worker, I speak to the labour hire company and I say, look, I need somebody to do labouring work on a site for 4 weeks. It's a building site, such and such award will apply, or such and such enterprise agreements in place. I can send you the details, just so that they know what sort of pay and conditions are being applied, and the labour hire company will provide me with the employee. Clearly then there's no relationship between the employer and the person that's doing the work. That employer is called a host, so they've got the person on site doing the work and they are hosting them. If they've got a problem with that employee, they're more likely to take it up with the labour hire company than they would with the employee. And of course, they can have a fairly low threshold of tolerance if for whatever reason they would just prefer somebody else to do the work. They can do that. They can say, look, this person's been a little bit disruptive on site. Don't want to have to explain ourselves. We just want you to send us someone else. And that's perfectly allowable. So you can see why the growth in this labour hire industry, and there's just about three companies there that I found straight off the website that are doing this work, and just becoming bigger all the time. Okay, let's just think about some taxation issues around contracting and employment. First and foremost, every employee is required to produce a tax file number once they start work. If they don't, they'll be taxed at the top marginal rate. Likewise, a business needs to identify itself to the tax office, and it does that by producing an Australian business number. In the absence of either of those, of course, the employer is obliged to withhold the top marginal rate of tax. Now, the Australian government introduced legislation in response to the claim that lots of people were entering into these contracting arrangements to reduce the amount of tax they were paying. And I'm talking specifically about the personal services income provisions which appear in the Tax Act. Now, you don't need to know these in detail, but just be aware that they are there, and that how they work is they ask the question, are you genuinely running a personal services business? There are some tests, which I'll talk about in a second, but the threshold thing is if 80% of your income comes from one source, then you're a bit on the back foot and you'll need to explain yourself. The tests which the tax office impose, and there are more than these, but these are some examples. Does the business advertise its services to the public? Does it engage other people to help perform the work? Does it have its own business premises? Are they paid to produce a particular result? Is there an obligation to rectify any defect in the work? And also they look at, of course, whether or not the business shares in profits and losses. So it's a slightly higher test than the common law test, which is in line with what I was saying before. For some purposes, legislation, particularly around revenue collection, can be a bit tougher. So in this case, the tax office has said, look, we don't care about the common law test. You might sort of look like a contractor, but unless you can meet some of these tests that we're going to apply in the area of personal services income, then we're going to deem you to be an employee, and you can pay tax as if you were an ordinary taxpayer. The other piece of legislation mentioned in your text, and which you need to have a look at, is the Independent Contractors Act. Now, essentially, all it was about was to prevent the states from interfering with genuine contracting. So this is legislation introduced under the Howard government, and its object in Section 3 was said to be along the lines of preventing interference with genuine contracting. So have a look at it. Section 5 and Section 7 too particularly. Section 5, paraphrased by me, says this is really an attempt to keep states out of the area of regulation of workplace relations for contractors. So the Commonwealth is saying, with respect to contractors, we don't want you introducing workplace relations regulations. And there are some examples given in the Act, but have a look at that for yourself. Just as an aside, because we'll talk about outworkers in the next chapter, the legislation does exempt laws that states make, particularly in relation to outworkers, and that's probably because of public interest. I would expect that there's a real public interest in both the Commonwealth and the states making sure that the most disadvantaged of workers, that is the outworkers, receive protection at the state and Commonwealth level. Finally, in this chapter 3, in the textbook, there's a reference to the legislative response to sham arrangements. Now, you'll hear a lot about sham arrangements in the area of contracting. Go back over those cases we've touched on and have a look at some of them. You'll see sometimes the claim is, as I said before, people wanting to be a contractor on one day, but once they're injured or they need to make some sort of claim, they quickly change their mind and want to be characterised as an employee. On other occasions, the whole thing has been set up by the employer as a sham, and that being the case, the Fair Work Act has reacted in this way. In these three sections, Section 357, 358 and 359, it's created a number of offences which trigger certain civil remedy proceedings. So in other words, well, offences might be too strong a word, but it triggers the ability to make a claim if any of these are breached. 357 makes it unlawful to misrepresent employment as a contract. 358 to dismiss a person with a view to re-engaging them as a contractor, and 359 to make any sort of false statements to a person to try and induce them to leave their employment and rejoin as a contractor. And then, as I mentioned earlier, Part 4 in the Fair Work legislation deals with penalties and injunctions which can be applied in the case that these things are proven. Have a good look through Chapter 3, please. Make some notes about those cases that I have mentioned, and in a moment we'll talk about, in Part 2, Chapter 4 of our textbook, we'll talk about some special types of employment arrangements.